Mr. Chief Justice, and may we please the court.
Mr. Parrish.
Mr. Thompson. My clients are here today, Mr. Watkins and his wife seated on the front row. Although this case has many of them, perhaps the ultimate irony is that I have the honor and privilege of representing Mr. Watkins, considering the career path that I've chosen as a result of his wrongful removal as county attorney in Van Buren County. Sexual harassment, we can all agree, is bad conduct. All bad conduct is not sexual harassment. Allegations of sexual harassment alone that may be considered bad conduct is not sufficient to remove a lawful elected official from office when the person making the allegation of a hostile working environment does not attribute it under oath to sexual misconduct. Although 4 other allegations were alleged in this thrice amended petition, not one of them, or all of them combined, were sufficient to establish willful misconduct or maladministration of Mr. Watkins. The district court's ruling failed to delineate whether Mr. Watkins was acting as an employer, private citizen, personal friend, or mentor at the time of the alleged misconduct. In essence, the ruling was devoid of context, which under Nelson v. Knight is an indispensable ingredient of finding of sexual harassment.
What is maladministration to you?
Maladministration, as the judge in this case combined it with willful misconduct, using willful misconduct as the vehicle to get there, it's where ultimately the actor purposely intends with an evil intent to harm the person. That's not established in this case. This is a very complex case. Its complexity, though, is due to the office, the living arrangements, the mixture of public employees with public duties in a private law office in a family home, which can create unpredictable, embarrassing, and unsettling interactions. In analyzing the case, we're asking the court to keep context in place. Context, as the court did, put it in 2 areas. The 2 areas they put it in was Board of Ethics cases and employment law. And in essence, they short-circuited both of those analyses that this court has built over the years. As people said, they created a slippery slope. Actually, it was a cliff that they created, in this case with the analysis of the district court's ruling.
Hey, before we get to the issue under our de novo review of whether the requisite evil intent was established, don't we have a threshold issue of was this case brought by somebody authorized to bring it?
There's 2 sections, 66. Obviously, the Board of Supervisors chose 331. And in 331, there had to be a conflict. We lay that out in our brief pretty succinctly. At the end, they adopted, behind the door, so to speak, 666, with 3 Board of Supervisors where the rule requires 5 voters. They had many other alternatives. They could have gone to the press. They could have had a recall election. They could have gone to the Board of Ethics, asked, as this court well knows, an emergency removal of the license of the person. They could have called him over, could have issued sanctions to Mr. Watkins. They could have cut off his budget. They could have told him to move his office out of his house into another place. They were equally advised of what the situation was by the same attorneys who was advising him. They had all of these other alternatives, but yet they chose the most punitive one through this process of Rule 331, and as they argued in their brief, maybe now they could go back and take advantage of Rule 66. There are some technical problems, we believe, in how the removal petition was brought.
Well, I guess I want to follow up on that a little bit. Is the Board of Supervisors even acting through a acting county attorney, are they even authorized under the statute to bring this petition?
Our argument is that they are not authorized under the 331 section because, for a couple of reasons. Number one, whether or not it's a civil action, but the judge the district court judge said it was punitive and said it was penal in consequences. So it really takes it out of the conflict under 331. Under Rule 66, obviously they had a whole different provision in which they could have brought it, but they chose not to do that.
Yeah, why wouldn't you normally do by the Attorney General in all cases? And of course, the individual involved in advising the Board of Supervisors here was in fact the former Attorney General who handled all these, but apparently, well, I won't editorialize on why it didn't happen, but there's so many other options here, but the Board of Supervisors as another board of elected officials doesn't, to me, appear to be the appropriate person to bring this underlying action, and I think maybe the motion to dismiss should have been granted at the outset.
Well, Justice Sager, we agree with you on that. And the other thing, you bring up a very significant point. He was a former Attorney General who supervised Virginia Barchman, who was the moving key witness in the removal, who is now county attorney. She was also the person who gathered the list together in August when they decided to file a petition for removal to go after Mr. Watkins, and was the one who worked with Tate Weeble, the person who was the nanny, when she walked over to the sheriff's office. And she now serves as county attorney in that office, so it was a critical point. So the same lawyer also advised the county attorney, Mr. Watkins, when he was there, advised the Board of Supervisors, and also advised the witness. But the investigator supervised Ms. Barchman, came down to Van Buren County, had a social lunch with her, then proceeded to interview other key witnesses, except he never once called Ms. Watkins. He never once called Mr. Watkins to ask them, nor did he even go over to look at the house, which we argued, and you can see photographs of it here, showed the layout of this particular area.
I agree that there's sort of an aroma to this case that troubles me, but what I really want to focus on is what's the legal standard. I mean, does it have to be, assuming your client committed what could give rise to civil liability for sexual harassment? Somebody could bring successfully a sexual harassment case. Is that enough, or does it have to be something that's closer to criminal conduct to justify removal of this sort of what we've called an extraordinary remedy?
Well, interesting, Justice Manfield, traditionally, and there are very few cases, and you can see we're all kind of flying blind in the briefs here, and you can look at other states. In other states, obviously, it's criminal conduct, depends on the statute. But traditionally, we have a 1910 case, the Meek case that we cited, and there's another case where the sheriff in Callaway was beating up 5 or 6 people over a course of 2 years. And we have the case, obviously, out of Cedar Rapids where they wouldn't stop baseball on a Sunday afternoon, and they reviewed those folks. Each time it's been almost some type of conduct that's criminal in nature. The question, did we short-circuit the process in this case? Without a doubt. The court created what can be an a la carte or almost hybrid type system where he borrowed from the sexual harassment statutes under Title VII or the Iowa Civil Rights Code and put those in play, but he didn't do the proper analysis. He also, in his analysis, took the sexual ethics case using Moothart as an example. But if you look at the Moothart case, each of those cases involving some type of consensual sexual relationship with the client, and if you follow every single case that's listed in Moothart, there's not one that talks about words alone being sufficient. And I go back to the other argument here is that context, if you look at the Nelson versus Knight case and a couple other cases that you've written, you talk about context as a 2.5-year relationship. She worked as a nanny. She picked up his personal prescriptions. They socialized together. They spent lots of other times in areas where were just purely personal in nature. That goes back to the question that was brought up by Justice Sager. It is a kind of a conglomeration of activity here where you have a public employee working in a private home. The judge did not consider any of those, and actually, to get to a standard, he never created one. And the cliff I'm talking about, let's project. What if this sexual harassment case, should the court adopt it, become the standard for employment cases without all the analysis? The whole process is short-circuited. Can we use it for removal?
Can you ever have a willfully creating a hostile work environment to remove a public official?
It would be difficult. The voters, when you have a recall process in Iowa, when you have a civil action that can take place, when you have, say, some type of assaultive behavior.
You say difficult, when can you have it then?
Let's say we have an assaultive behavior where there may be a conviction or indictment or something like that. That's
Well,
the
let's,
area that we've looked
back
at.
off a little from that. I'm going to follow up, but supposing you have an environment, a work environment that is pervasively sexually hostile.
Sure.
And let's just say the record shows that day in and day out, female staff in the office are treated with disrespect, with innuendo, with smart comments, quote, you know, that kind of thing. But let's assume the record also shows that there's been no dropping the ball in criminal cases, and, you know, kind of the public conduct has been well taken care of. But the problem in the case is in the office, it is just drenching with sexually hostile remarks. Under that hypothetical, can the county attorney be removed?
If it was in the county attorney's office, not comparing the hypothetical that you gave with what was taking place in this office, there may be some steps. First of all, there should be a warning. There should be a removal proceeding. That could be an ethics complaint filed against the county attorney, he or she. There can be press releases that, as they did in this case, they weren't shy about creating the impression that Mr. Watkins was walking down the street from his home to his office, if you read the petition, in his underwear. That just didn't happen. But there can be a situation that creates such an emergency that you would want to take some removal action, and if it was directed, again, you have to go back. If it's sexual harassment, you have to, again, put context. And in your hypothetical, I think the context may be a perfect storm, so to speak, to take that action. But still, there are alternatives. They can still do a recall. They can still go to the press. They can still file an emergency proceeding that can end up in this court's action. But if you created a hybrid and said, that's how we're going to do it, that's not how it's going to be fair to any county attorney or public elected official. And go back to Justice Sager, if you take one public official and you take the process to remove another public elected official around, remember, Mr. Watkins is an independent. So when he ran as an independent, he may be running adverse, even though the Board of Supervisors said he was giving them good advice. They never criticized his advice, but they said what was happening in his office, even though it was long removed, the petition for removal was not filed until September 29th. This kind of blow up, a dust up in the office occurred in August, about August 5th. And the ultimate testimony in this case was a person bringing a complaint, Ms. Wallerford, and we're not asking for the endorsement of these statements that were made. And I think this court, in ultimately reaching its opinion, doesn't have to endorse these statements. But she testified under oath that the reason for the hostile environment, after the letter she wrote, and even after the affidavit prepared by Tom Miller, said that the reason is because of the fights in the office between Mr. and Mrs. Watkins. Had nothing to do with the allegation of sexual harassment, and she also said she was not a party and was not going to be a plaintiff to that. Now, that doesn't stop if the person's not a plaintiff to it. I'm not saying it will stop any other removal action, but you have to look at the unique facts in this case and the circumstances in this case, and the county was also aware of what was going on in this case when it came about. So our words alone, without proper context, cannot create sexual harassment. Courts after courts, including this court, has talked about that. And you have to look at the relationship. Other than that, look at what else the court missed in its analysis. No allegations of anything on his computer, no allegation of operating out in his office, nothing in the clerk's office that talked about any interaction that was improper. The Board of Supervisors said that his work was good, it was timely. Even the client who came in the one day, who he had known since high school, his high school teacher, says, oh yeah, the will was perfect, everything was drafted up. And again, the other four counts, Your Honors, before I close, that they brought that started this process never had any substance or merit. Thank you.
Mr. Parrish, thank you. Mr. Thompson.
Thank you, Chief Justice. Good morning. May it please the court. Chapter 66 obviously fulfills an essential public purpose here. This court, all the way back in the Meek case in 1910, said the purpose is to rid the community of corrupt, incapable, and unworthy public officials. There are always difficult cases. Here, the district court reached the right result.
Who decides who's unworthy? Is it the judge or our court, or is it the public? Because he's an elected official, and he's going to be on the ballot soon enough, and isn't it more of a political problem than it is I mean, I think if the person's arrested for some felony, you know, and can't fulfill their job because they're in jail, that may be a reason to do it, but, I mean, why shouldn't we wait? Why shouldn't the citizens wait for the next election to see what the citizens of the county think?
Well, two ways to answer that. I think, first of all, the preference is for the democratic process to take its course and let the ballot box answer the question. Chapter 66 was put in place because in some cases that doesn't work, or it doesn't work quickly enough, or because the gross misconduct was sufficient to really draw concerns about the office itself. And so here, I mean, simply put, Abraham Watkins' conduct, specifically his treatment of female county employees, rendered him unworthy of the office of Van Buren County Attorney. This court has focused on, in the Bart's case.
How do you quantify unworthiness? That's what
Well, I mean, so.
tell me what you quantify unworthiness is, not by defining it by conduct that's unworthy, but a definition that would apply across all spectrums.
Well, this court has done that. I mean, this court, the two most recent cases in Callaway and in Bart's, this court upheld removals. And in Bart's in 74, the summary that this court made was that the activities in office fell well below the standard of conduct expected of a public official.
That was conduct that I think you could have scanned the statutes and found criminal charges there. I mean, there were slush funds that were being operated by those officials. I mean, what troubles me is the notion, is it your position that if a public official commits sexual harassment, that is grounds under Chapter 66 for their removal?
Well, I think to answer a question you already asked, I mean, is conduct sufficient to create risk of liability enough? Absolutely not. I don't think so. And so that's not what we're saying. But I do think that there's a distinction. If you look at Bart's, and there's a line of various cases over the years, this court has talked about financial mismanagement, bad business judgments, basically financial transactions, and has said, regardless, I mean, there was even ones that were technical violations of the law, this court has said, hey, if it's money damages, if the bond can cover the public, then that's not enough for removal under Chapter 66. But
Let me give you an example. What about, let's say, IPERS, it's been in the press. I mean, there are things where have not worked out. There have been losses. There have been allegations of negligence. Could you remove the responsible officials? Could people of a different political party from the people that control IPERS remove the responsible officials through this device? Isn't that kind of a troubling scenario?
It can be, but I think the protections are still in place, and I can walk through the concern about the filing, because I understand when you combine 131 together with Chapter 66, you get a result that may not be obvious, but I think it's a result the legislature invited and put in place in 1981 when they passed the Home Rule statute after Chapter 66 predecessor had been on the books since 1909. So the legislature knew.
Well, home rule to me is pretty much an all-encompassing type of grant of power. You know, to me, when you have a very, very specific have here, and under 66.3, when you have specific, who may file the petition, nowhere listed there is a Board of Supervisors authorized to file a removal action. I mean, we have 5 different mechanisms to do this, and again, I'm very troubled, as you can have already determined, by the Board of Supervisors, you know, again, by their own language, you know, manipulating, we're gonna have to do some legal wrangling under 331 to allow you to do this, make you have to determine that there's a conflict of interest. So now you have the board, you know, the whole thing just isn't right when we have a clear mechanism here. And so you know, you're gonna tell me that, well, I think it's still authorized under 331, and I'm saying when we have a very specific code section here that says who is authorized to start this, and you don't utilize it, then that's a problem for me.
Well, two things. I mean, statutorily, I understand the concern, but number one, the county attorneys didn't file, I mean, the county commissioners didn't file this action. A lawyer did, and that lawyer had been appointed in accordance with 331 as acting county attorney, and the legislature passed that law, and then that law also says that that attorney has all the authority of a county attorney. And when you go to
Yeah, but
66...
the code section that you're relying upon, I've never, ever seen it utilized for this purpose. When you have a conflict of interest within the county attorney's office, the county attorney and/or the assistant goes to the Board of Supervisors and says, hey, we've got all these conflicts of interest, you know, we can't handle it within the office, and that would be particularly true in a small county like this is.
Absolutely.
We can't handle it, so you need to go ahead and appoint somebody else to act as acting county attorney, not the way that it handled here, where they just carte blanche decide, well, this office has a conflict of interest, so now we're gonna sidestep that authority. We're making the determination there's a conflict of interest, and now we're gonna just appoint somebody on our own to do that. It just seems absurd to me.
And it may, but on these facts, as the district court said, the conflict is on its face, right? The complaint is by employees of the county, the only assistant, a county attorney being one of them, and the complaint is against the county attorney. And so the conflict presents itself, frankly, and so the commissioners have an alternative. And it is a complaint which they have a legal obligation to take action on under both state and federal law. And so I'm not saying that this is the way it should always
They have
work.
an obligation to take action, but they don't have an obligation to to hire another an acting county attorney and then direct them to file a petition for removal.
They don't, but they have the legal authority to do so. I mean, I understand you don't like it. I don't know that I necessarily
Well,
like
I'm
it.
not
but
sure
the
that
rea-
it's
You know, and I'm
legal.
often have to argue up here things that elected officials have the authority to do because the legislature gave it to them. But there's no doubt Chapter 131 gives the Board of Commissioners authority to appoint an acting county attorney. In fact, if you look at that statute, it's got layers of different ways to handle conflicts. And they could have put Chapter 66 in another subsection where there had to be a different kind of mechanism, but it wasn't. It's a civil action, it's an action in equity, and an acting county attorney has all the authority. The other thing that's important here, though, in terms of checks and balances, is a district court approved, it's a verified petition, and the district court accepted it, and then the district court also, on motion of the council, appointed a special prosecutor under 6612, which is another mechanism that's called out in Chapter 66. But I want to get back just really quickly to your specific versus general argument, because I know that's in the briefing. 131's the more specific statute. 66 deals with Chapter 60, and it lists a whole bunch of different people that can file it. One of them is the county attorney. 131 deals with the powers of a county attorney. I think it's more specific under the Sarcone case. I think, therefore, I don't think there's a conflict. On the plain language, you can read it, and it applies. You may not like the result, but the statute permits what happened. Even if there were a conflict under the rules of construction, the more specific would overrule, and the more recent would overrule. So under both canons of construction, 131, if there's a conflict, permits this acting county attorney to file the matter.
Who's the complaining party or parties in this case?
I mean, it's really the state. I mean, it's always brought in the name of the state, but it can be brought by a list of certain people. And so in the end, the complaint, it's not an employment case. So the complaining parties aren't the people complaining of harassment. those are the facts that arise from an investigation in this case, but in the end, there's a decision that people have to make. Commissioners were involved, but an acting county attorney, who's an attorney that has ethical obligations, made a decision that the investigation revealed information that warranted a Chapter 66 removal.
So we
It's
read
the state.
we read the statute, Chapter 66 as a whole, and we read it together with the other statute. But there are provisions in here, and I'm trying to just make sure I track with the argument. There's one, was a bond posted?
No, because it's under 66-4, a bond is only required if citizens file it.
Okay. And then I'm not suggesting this, there was a one of probable cause
Right.
here, but had there been, and then a fee shifting, who would pay in this case?
Right.
The
So in this-
state or,
In this case, the county would,
okay,
because it's brought by the county attorney and then by the special prosecutor also being appointed by the court. Under either circumstance, the county pays it, or the city, if it had been a city case. If the AG had filed it, the state would pay. And if there was a lack of probable cause on a citizen-initiated complaint, then they could be charged with costs. And so the two things, I mean, to the end-around argument, the only things that don't get invoked here out of Chapter 66 is because it's not a citizen action, there's no bond required, but the county's good for the judgment, right? So it says who's gonna pay the judgment if there's attorney's fees, and there's no probable cause step that the court goes through before they accept the petition.
I just
Those are
have
the two.
a question for you, and you may or may not be able to answer this, but obviously the individual involved in this handled all these for the Attorney General's office for many, many years. Why wouldn't the Attorney General's office undertake the same representation in this case as has been done numerous times by this individual or by the Attorney General's office anyway? Why go through this whole mechanism of the Board of Supervisors and appointing a county attorney and then having the judge appoint a special prosecutor when clearly the Attorney General's office is the entity that normally does this?
The answer is, I mean, Tom Miller was acting in his capacity as a private attorney. He'd been called in and hired initially by the insurance company, and then was also retained by the county under 331. And so he was acting as a private attorney. He did have experience, but he had no ability to recommend to us or control a decision that the Attorney General would make.
But the question I have is, why doesn't 6612 kind of occupy the same territory as that you're talking about and say, this is what you do when the county attorney is the person that might be subject to removal, and kind of occupy it so you can't go into another chapter of the Iowa Code? That's the concern I
I don't
have.
think it does, because the way it's written, I mean, it's a little, it presumes, it says when an action is brought. And so one way to interpret that would be you could go to the judge, anybody could go to the judge and have him appoint a special prosecutor. I think conservatively you read it that the case has to be filed because it's brought. And so I think out of an abundance of caution, what they did is they appointed an acting county attorney under 331-754, but then in the petition recited the appointment. It's there on a verified complaint, but then in addition to that, asked the court to appoint that acting county attorney.
It just seems like a very refined reading, because it seems like that solves totally the problem of what you do when the county attorney has a conflict of interest, and why do you need to go travel into another
The only
area
question
of
I
the
would
law?
ask is who files the petition?
I mean, I guess I would say you go to court and ask the judge to appoint. What they didn't do was go to the court and ask the court to appoint, say, Mr. Brown and Mr. Miller to bring the petition. I suppose they could have done that. They didn't.
Yeah, and I understand that interpretation. I think that, especially in the context of the statute that says who may file, and then it lists people, and then it says if it's brought, I think there's some ambiguity there, so I
I think
understand.
file and broad are meant to be interchangeable. I mean, that's a pretty fine distinction, isn't it?
It may be, but I think either way, I mean, so they invoked it with the court. If that's your reading of the statute, Your Honor, then they did invoke 6612, and the court entered an order appointing Monty Brown as special prosecutor, and then we're dealing with the technical argument that they never had the authority to file the petition in the first place. So if it does occupy the field, then they complied with it, because there's a court order in the file appointing Monty Brown as special prosecutor for purposes of this case, and my time's up. Thank you.
Thank you as well, Mr. Thompson. Mr. Parrish, rebuttal.
Thank you, Your Honors. I'd like to go to Justice Zager's and Justice Mansfield's response. I think the chronology, the state has a little bit mixed up. Ms. Barchman filed a retaliation complaint, and that was not until after the original petition was filed. So when he says that she was one of the complaining party that initiated the removal action, if you follow the chronology, you will see that she came in later as retaliation. That retaliation claim was later withdrawn by the state and was not part of any ultimate resolution in the finding by the court, along with the three other matters in this matter. And Justice Zager, I want to follow up on one other point that you made too, and that's with regard to how this all came about. And it's a critical point that would cause all public officials, elected public officials, to start shaking in their boots right now, because they went without consulting the county attorney, hired an investigator who was friends with Ms. Barchman, brought him in, went to their insurance company, and it's all laid out in the material, and began talking with them without even consulting the county attorney. First of all, if there had been consultation, he would have been on notice as to any conduct they were concerned about. The state argues that, well, the state was the party in this case. The state can't have a claim greater than the person who is being sexually harassed by the way that this ruling is written up. So if you go back and track the logic of the ruling, if the state says, well, hey, we're really the party here, how can their claim be greater than the person who is a sexual harasser, which has to be the underlying basis each time this court is set? Let's look at the underlying basis. Each time you analyze a fact, you go to the underlying basis to see if it's there. That was never done. Further, there's a critical point here. There is a tape conversation we got in the discovery. In it, the Board of Supervisors asked this question: what about Mr. Watkins and treatment? This is in their meeting. The investigator, who's never talked to Mr. Watkins, responds. He never went to treatment. He refused. Before they filed the petition for removal, that was an ultimate question. That was a false and incorrect statement put forward at a Board of Supervisors meeting by the investigator who had never talked to them, and Hugh Grady contradicts them. They said he hadn't had a drink since August 5th. The petition was not filed until September 29th. That was one of the critical points that caused the Board of Supervisors to go forward with the petition for removal, because that was an ultimate question they wanted answered. And when they didn't get an answer to that question that they thought they needed to decide what would be some alternative action, such as filing a complaint, doing a recall, moving an elected official in some other manner, they proceeded then with that petition. The chronology here is extremely important, just as it's important to go back to context from the date in 2014 when Ms. Wallerfoot was hired, and go forward and talk about all of their interactions to create what you laid out in Nelson versus Knight. You also have to put context in this case to get to the underlying fact.
Are you saying that the conduct allegedly found by the district court is proper to run an efficient office?
It's not. What I am saying is that, number one, it's not sufficient for removal of a public elected official, number one. Number two, if you look at the context over a period of 2.5 years and the interactions and kind of the blurred optics that this office had of public employees working within a private law firm that was also running a private law firm along with a public law firm, and she was also doing his personal work. You have to look at it in that context. As I said early on in my opening argument, we're not asking for the endorsement of these statements or comments. In order to get to an ultimate ruling in this case, you don't have to do it. But I'm not saying but you have to put it in its proper context to be fair to Mr. Watkins and other elected officials, where you not only would create, as I indicated, a slippery slope, but this court would create a cliff for elected public officials. So we believe, for those reasons, unless the court has some other questions asking me, this case ought to be reversed, and there was an improper removal of Mr. Watkins as county attorney. And it's ultimately the voters who should have decided this, or other alternative actions that were all available to the county in this case. Thank you, Your Honors.
Mr. Parrish, thank you as well. The case of State versus Watkins is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.